Samuel is a leader in the development of legal artificial intelligence and the founder of AI Legal Assistant. He's guided hundreds of law firms through the process of choosing, adopting, and implementing legal artificial intelligence. In 2017, Samuel began developing with AI, recognizing its significant potential early on. Leveraging his 25-year career in business and technology, this led to the launch of AI Legal Assistant, which solves some of the biggest challenges for legal professionals. Let's dive straight in. Jenny, Samuel, what do you see as the positives and negatives of the practice note, and how would you like to see things done differently?
I might kick off on that with that, if that's okay, Beck. I think to start with the positives, there's a lot of good things in the note. That part of it is you think about what the purpose of the practice note is, and that is to ensure that the information that goes before the court is properly reflective of, say, for example, what a deponent's true opinions are, and that the information provided is accurate and doesn't mislead the court. So reinforcing those things, which are really critical for the operation of the justice system, are very good things to do. However, I think that there's, unfortunately, I think the negatives outweigh the positives. While I could talk about a lot of those, I think the main things I really want to pick up are how does it interact appropriately with the existing rules of ethics and conduct? And is it actually, particularly by focusing on specific use cases, is it really sort of shooting the whole process in the foot? Is it going to be letting through a whole lot of other use cases which are inappropriate, and at the same time thwarting good use of generative AI? So I guess the starting point with any of this, if any of the work is really, how is AI being used in a way that's consistent with the lawyer's duties to the court? So the duty to the administration of justice and the duty to the court. And for somebody who's got their microphone on, it's making quite a lot of noise. Yeah, okay, thank you. The way lawyers are regulated, they are very, very aware of the fact that they owe duties to the court, that they have to give information to the court which is accurate and properly reflects the truthfulness of the position. So, for example, there have been a number of cases that have really sparked this intervention with the practice note. One of the most recent being a case in the Federal Circuit and Family Court of Australia, which is currently reported under the pseudonym Dale. This is a case where a lawyer used the legal research tool in the Leap AI to put together a series of cases for the submissions to the court. And it turned out that 5 of the cases were fake cases, so they were fake hallucinated citations. The lawyer has been roundly criticised for this and referred to the Victorian Legal Services Commissioner for investigation. And it's interesting when you read the judgment just how clear it is, how embarrassed and how mortified the lawyer is by their own behaviour. And I think that this really points to the fact that lawyers are actually very concerned to do the right thing in a lot of ways, and they are certainly very concerned about the implications for them if they don't do things in the right way. So shame is a very powerful mechanism for controlling human behaviour. And the shame of being disciplined as a lawyer is something that really speaks to them. So I can speak as somebody that spent many, many years in ethics and regulation and dealing with complaints, that the threat of a complaint and the threat of disciplinary action is really enough to make lawyers behave themselves. And these kinds of cautionary tales where people get caught by the court using hallucinated references and also putting together fake information, this is the sort of thing that is sufficient to really control the actions of a lawyer. So I think for that reason, really what we need to be thinking about is the document that is being produced to the court accurate, verifiable, and a true, in the case of affidavit, a true reflection of the deponent's beliefs. Now, the banning of using AI for the generation of an affidavit, for example, isn't really enough to control the lawyer from doing the wrong thing if they want to do the wrong thing. So I think it's a mistake to kind of fixate on particular artifacts or particular products without looking at the process by which somebody has created that affidavit. Again, on the basis of the ban of using AI in affidavits, there are ways of creating affidavits that are fake that frequently comes up. So there's the story where people usually find out if an affidavit is correct or not, or it is a true reflection of a person's beliefs. In cross-examination, they'll ask them the meaning of certain words, and if the deponent doesn't know the meaning of those words, you can be pretty sure that the lawyers drafted it rather than reflecting the accurate words of the deponent. Whereas with good generative AI, you can actually take a transcript of a detailed conversation with a client and get a draft affidavit that does include the client's own language. So mistaking the output for the process by which the output is generated, I think is one of the key problems that I have with it. I guess for me, the main issue is you really need to be what? Sorry, could you please mute?
Sorry, if we could just ask everyone who's not speaking to mute their microphones, please. Thank you so much.
So the main issue is that we really need to think about the principles behind the what needs to moderate or what needs to govern how AI is used rather than thinking about particular artifacts. So I might throw over to Samuel now, and because I'm sure he'll have a lot to say, particularly about the technical aspects of the guidance and the practices.
Thank you, Jenny. That's a very good summary and intro. I was almost thinking I could get off the hook and go up for one and lead it to it. So I completely agree with what Jenny's saying, and I think it's quite interesting to see how we have this tool that's come onto the scenes, and then all of a sudden it seems like the tool is the enemy, or this is the thing that is corrupting practitioners. It's not necessarily the case, as Jenny mentioned, with affidavits. Affidavits could already be drafted by someone else other than the person who was, whose affidavit it is. So there's no real difference in some of these situations, but they're being very specifically, picked on or highlighted in the practice note. And fundamentally, if we go back to Beck's original question, I think that fundamentally the practice note does in some ways undermine a lawyer's intelligence, and it undermines the whole reason why they become a lawyer is to make critical judgments and decisions. That's not to say that there won't be some lazy, bad actors. There's always going to be, and there always probably will be, unfortunately. And on the flip side of that, the ones that actually learn how to use generative AI properly will go completely undetected. I'm not suggesting that everyone should go out and learn so that you can be, undetected and go against what the practice note is saying. I'm not saying that at all, but what I am saying is that the education piece here is so fundamental, and we'll hear that come up in this discussion quite a bit, is that the ones that do get educated on using these tools will go completely undetected with any rules that come out, not just the practice note, but, the practice note, I guess, is the first major piece to come out around compliance and the use of AI, and there's probably going to be a lot more followed at various different levels of regulation. So if you think going forward, how do we utilize, I call it the soft and the hard, right? The soft is you can go and put rules in place for people and say you need to abide by these rules. Some people will, some people won't. And that's the softer side of things. The harder side of things is from a technological standpoint. how do you build the technology in such a way that you don't end up with certain situations happening? And this is where we, as a leader in the space of building AI technology, comes into the discussion, and we're quite disappointed that they didn't confer with anyone from the tech space. It seems, I know there are some people who have dabbled in AI that consulted on the practice note, but they didn't actually bring, from what we know and the people that we've spoken to, they didn't actually bring anyone in that specializes in building the technology, the harder side of things, where we can actually govern what goes on and how people utilize it. Overall, like Jenny, I understand where they're coming from. And it's kind of like that old saying, to a man with a hammer, everything seems like a nail. You know, their hammer is to create regulation around something to try to get a better outcome. And I don't disagree with the purpose or the intent behind it, but maybe the way that it's being rolled out is not the most effective way of doing things necessarily.
Yeah, look, I'd agree with that, Samuel. And I think I think it's one of those things that if you think about how is the practice note actually going to be enforced, is there going to be some sort of forensic process for working out whether generative AI was produced was used in producing any particular document? Will there be a basis for lawyers to put in an application to strike out certain documents on the basis that AI was improperly used? And what's the forensic process for actually discovering whether that's true or not? And the other thing is the process for getting the court's consent in advance of an expert using generative AI in the preparation of an affidavit is likely to be a very expensive process. Why add in another interlocutory step in what's already a prohibitively expensive process of litigation, rather than have another way of doing it, which would be for the expert to simply describe in the course of the information or the evidence that they lodge, how they actually use the generative AI. I just think there's a lot of it's a classic case that the devil's in the detail. If you think about how to actually implement this note and how it's going to play out in practice, there's a lot of ways in which I can see increased expense and increasing complexity resulting from it.
Which is quite ironic because, if we look at the legal industry as a whole, there's so many problems that AI can solve. We look at every week, there's more and more legislation that's passed and added to a system that's just becoming more and more complex and overbloated. And barely anything repealed in comparison, right? So everything is getting more complex. There's more information to wade through. AI can very quickly and easily make it easier for practitioners to actually get to the source of truth and be able to compare things when you've got huge amounts of data to wade through. I'm not saying that that people don't need to use proper judgment when it comes to looking at that information. But then you look at, I think the statistics that I saw recently, where 33% of all Australian lawyers are still working over 50 hours a week. We look at all the mental health issues that are running right through the industry. And AI can solve a lot of these problems, lighten the workload, and it helps to get to the same outcome in a much faster time. But then it's being negated by all these extra regulations and processes that need to happen to be able to use AI. It's just a little bit absurd. Jayanne, can you mute everyone that is in the foyer, please, or in the room, so we're not getting background noise?
Samuel, that's probably a good moment to pause and just remind everyone that if you've got questions or comments as we go along, please feel free to jump in. This is a conversation and we'd love you to join the conversation. So just to summarize, Jenny and Tamara, what you were saying, it sounds to me like using a practice note to regulate AI is almost like trying to catch the horse after the horse is bolted. Because if we're looking at it from a technology perspective, there's hard controls that can be implemented by technology providers. And then we've also got soft controls that are already in place through regulators like the law societies. So would you agree that that's an appropriate characterization of using a practice note to try to regulate AI use?
I think it's not so much using the practice note, but the particular practice note, the sort of approach that's been taken. This one is just it's far too focused on addressing things that have already taken place. So to that extent, I think it's right to say that it's closing the stable door after the horse has bolted. But it doesn't have, I guess, when thinking about it as a regulator, what you're really trying to do is to address real risks that have definite harms. And I feel that the problem is that there isn't a sufficient understanding of what the risks are. So it's a bit of it's quite a limited understanding of the kinds of risks and the kinds of benefits that AI generates, which really comes from, I think, a fairly shallow understanding of how the technology operates and how it can be used. So I think from a regulatory point of view, it's very reactive rather than really understanding the field that they're trying to regulate. And in that sense, it really required a lot more research and a lot more public discussion before the practice note came out and the rules were amended. So I think my main criticism is really around the basis of the understanding or the underpinning understanding of AI that informs it, and also a very unsophisticated understanding of the sorts of risks that might occur.
Absolutely. And I think if that's what you're alluding to, there's also other risks that were not mentioned in there that that the practice won't solve, that they haven't considered. And also, if you look at paragraph 6, there was a number of things in there that assume that what is out there is already accurate. So things like saying that chronology software can be used, but it has the same flaws that the practice note is trying to solve, where existing chronology software can bring back inaccurate, bring back inaccurate representations or inaccurate information, which is fine, because at the end of the day, it's the practitioner's responsibility to go and fact check that. So the chronology software may make it a lot faster to put the chronology together, but they still have to go fact check it. The same holds that they should be fact checking everything that they put together in your case before about affidavits. If people were to use it for affidavits, putting the practice note aside, they should still be fact checking it to make sure that it's a true representation of what it's meant to be used for. I guess the misunderstanding or the inference with it is that people are going to use it to create false information to try to win their case, which absolutely should not be used for. And that should already be implied as being a practitioner. It goes back to what you were saying before about the kind of the standard ethics and principles of being a lawyer.
Yeah,
why is it any different?
I think one of the other things that's worth considering is that when I worked in complaints in particular, it was amazing how common self-represented litigants on the other side caused issues in various ways. And while I don't want to kind of put all self-represented litigants in the same basket, there are some that are kind of a little obsessive and a little too wedded and too close to their own to their own case. And I really feel that the note didn't do enough, or there doesn't seem to be enough focus on the possible use of generative AI by self-represented litigants, whether for good purposes or for more nefarious purposes. So I think the case in Canberra where a character reference was generated by AI actually involved a self-represented litigant. So again, it's really not enough groundwork and not enough research going into the consideration of risk that that really underpin what the note should be looking at. So, yeah, I mean, it's it's a difficult situation because you don't want uh, the perfect to be the enemy of the good. That you do want to get something out there, but at this stage, really a much higher level, more principle based note. For example, like they had with the Supreme Court of Victoria note, is more principle based, and I think that that's a better approach at this stage. But yeah, need to do a lot more work understanding how self-represented litigants use the technology and what the risks and benefits are there.
Yeah. And I think, potentially the self-representing ones are the ones that need AI assistance more than the ones that can afford proper legal representation. Because they are, and one of the interesting things that it pointed out is that, Google searches, it doesn't it doesn't include Google searches. And it's like, how much fake information or inaccurate information have you found on the Google search, right? And this is what the self-represented are utilizing anyway. So I'm not saying 100% pro AI. I'm not saying 100% AI is accurate all the time, but it's just this sweeping, broad brush strokes regulation, which is very biased in many areas, I guess. If you look at some of the existing use cases and tools that are being used today versus the new generation of tools, you say. So maybe let's move forward. And do we want to run through the what people can come to if they're in New South Wales? Well, I realise this might not cover everyone on the call, and everyone might not be in New South Wales. But the thing to consider is, because this is one of the first major pieces to come out, other states may follow suit and, for lack of a better word, may just copy and paste what we've got here. And if what we've got here is fundamental or got holes in it, do we want it being rolled out to the whole country and it being replicated everywhere? Probably not. We need more nuanced discussion, and we'll talk a little bit more about what Jen and I are thinking, in a moment. But should we go through those now, Jenny, and maybe just put it black and white to people that are still wondering?
Sounds a good idea.
And maybe as well, perhaps at the end of that, if you could also, Jenny, cover a little bit around the principles-based approach that Victoria's taking, then that would be a good contrast in compare between the two.
Yeah, should.
Thank you.
So we'll just go through this quickly. As I mentioned, not everyone is in New South Wales, but if it's replicated everywhere else, then it would apply to everyone. So what you can use AI for in this broad, the black and white terms, is drafting general documents, contracts, summaries, as long as you're not coming up with evidence. And I kind of feel like we shouldn't even need to say this, that you shouldn't be using generative AI to come up with evidence or, confidential information. It's just kind of like, do not pass go, do not collect $200. It's like the fundamentals of being a lawyer, right? Legal research, there were some conflicting things in the practice mode where it's naming things like Lexis AI and Westlaw, saying that these are generative AI tools and they shouldn't be used. But then later on, it's saying that you can use generative AI to do research. So without going into it in too much detail, I'm not trying to pick on anything specifically with the practice mode. It's just highlighting the fact that it hasn't been thought through properly. Even the fact that they call Google Gemini, Google Bard within the thing, Google Bard was changed to Google Gemini 9.5 months before the practice note came in.
I think the other interesting thing about the legal research tools is that the best of those, there was a study in the US not long ago that compared a couple of the Westlaw tools, Lexis Plus AI and ChatGPT-4 for various legal research tasks. And the best of them was the Lexis AI Plus, but that still had a 30% rate of incomplete or inaccurate results with still a number of hallucinations. So they're not foolproof, these tools. And I think that's the thing that you really, anybody who uses these tools and knows what they're about will be careful in the way that they use them. They don't take everything as gospel truth. They, you verify, you trust but verify, basically.
Yeah, and that's the interesting thing. Well, on one hand, they're saying you can't do it, but on the other hand, you're allowed to use it for research. So it's quite interesting. But the fixing grammar and spelling and formatting, I was using another grammar tool that I use earlier today, and went through and clicked accept on some of the changes that it recommended, and then looked at what I just accepted, and it was incorrect. Right. So they're saying that you can use these grammar and spelling tools, and yes, it's not generating whole swaths of text like a generative AI will. But if you think about that for a moment, just changing the grammar of something can completely change the meaning of the sentence. Right. So what's the difference between, fundamentally, what's the difference of an AI generating something that's come out of your own mind, where you give it a brief and say, draft this, or using a tool to correct your grammar and changing the meaning of what you've just written? There is no
exactly.
difference.
I mean, I think that's the thing. I think that not kind of going to the general principle that you always verify absolutely everything you produce using AI. It can maybe give a false sense of security over certain tools and not others, but where that in neither case is it really justified.
And this brings up another point, is because right now where we're at with AI from a technical stand is it's as bad as it's ever going to be. It's pretty good already. So over the next 6 to 12 months, we are going to find that the technology reaches a point where it is completely and utterly indistinguishable from human. The error rate will go down significantly. The problem that's going to bring up, which it doesn't seem like they're considering yet, as the accuracy goes up, people are going to start to become more and more complacent. Right? So they're already seeing signs of that now. But so how do you fix that potential complacency? But what can you not use AI for in New South Wales? Evidentiary documents, as we mentioned before. So affidavits with the statements, character references, they must all, it says, these must reflect a person's knowledge and words, which if you're asking AI to piece together your discombobulated thoughts and put them into, something that's coherent, that's still a representation of them. Without splitting hairs, if we're looking at the facts, we can't use it for those things. Confidential information. So one thing that the practice note points out, and it is true, and it is a very valid concern, is you don't want to be training an AI on private confidential information. You never want to be uploading documents to, say, a ChatGPT public model without privacy mode turned on and all that sort of stuff, because that information is then going to be used to train the AI. I think, going back to broad brushstrokes again, the practice note, as I said, all generative AI just sucks in all of your private confidential information, and it is used to train the model, which has just got through. Our models, for example, do not do that. We're never going to go down that route because there's just too much risk. So again, if this meeting drops out, we're just going to restart this meeting then with the same link. So apologies for that. I don't know how this was set up. I just turned up, and so if it does cut out, we'll just jump on again. Judgments and reasoning. Look, I won't say that it can replace judgments, but what AI is very good for is clarifying your own thoughts. We all know we get blocks with our thoughts, the classic writer's block. We still get that as practitioners, and AI can be very good at playing devil's advocate about what it is that you're, whatever it is that you're producing, an argument that you're trying to make, can be very good at playing another party or sitting on the same side as you and overlooking information. One real example for me personally, I sold a business last year. It was quite a large, complex transaction. There was entities in Australia, Hong Kong, the US. There was 8 documents in that transaction. I signed off on that. I had senior lawyer, a principal of a firm, and his senior associate acting for me. On the other side, we had 3 senior lawyers in a much, much larger firm and 2 buyers. Everyone signed off on all of these documents. And this year, we took those 8 documents, put it into the AI and said, we want to find things that are missing, conflicting, or just plain inconsistent. And it came back with half a dozen things that my lawyers even admitted, yes, we should have included those in the transaction had we known about them. And they said, look, we would have probably picked up on those if we spent another 10, 20 hours going through. But the thing that they're not highlighting is where it can actually increase the accuracy and mitigate risks, because you imagine the comeback. One of these half a dozen things had significant impact, and one of the parties, gets down the road and has a big blow up, and it's going to fall back on the lawyers that missed it. Right? But AI in this case, if it had been used, would have picked up on these things that the lawyers could have included or amended within that set of documents. It's not to say that the AI is 100% perfect all the time, but what we know is that AI picked up on half a dozen things that should have been included in the transaction in 1.5 minutes that 8 people miss.
Yeah. I mean, that's a really good example, isn't it? And I think the thing is that humans are not 100% reliable either. So I think anything that kind of supplements us as lawyers, because we're a 100% profession, anything that supplements us and helps us to be more accurate is a really good thing.
Absolutely.
On that, Jenny and Samuel, could say obvious good use cases for AI for many reasons, including burnouts, managing psychosocial risks or hazards, managing compliance risks, accuracy, improving quality and outputs. What would good look like, in your opinion, if we are to implement AI widely amongst the legal profession? What would that look like in terms of governance frameworks and the technology?
I think for me, like if I can start at kind of like a very high level outcome, what good looks like is increased access to justice for the missing majority market of legal services, potential legal services consumers and clients. I think anything that enables the lawyer to produce good legal services more quickly, more accurately, at scale, and for a better price, which will enable a lot more people to be able to get proper legal advice and to be able to get help where they can't sort out the problem themselves. Anything like that would be really good. I think generative AI, for example, has a really massive potential for making limited scope legal services a reality, particularly if you've got specialized GPTs that it can enable people to get information from a very defined and carefully locked down body of data. Any of those sorts of things, I think, would be the ideal. Coming back a bit more closer to the current realities, I think people need to have good policies in place. So figuring out which kinds of tools they're going to use and how they're going to be used, and working out how to use generative AI not as a means of outsourcing, not something that you, like delegate the work to, but something that can help you with the work. So an assistant that is at your elbow rather than somebody sitting in another office that you give work to. So all of that governance in terms of law practices, choosing the right tools, learning how to use them properly, experimenting together, having the right data security in place, all of those things I think are critical.
So I think, potentially how we get there is, certification, or education or certification around this that sits alongside some regulation, saying regulations to also be practical. But I think a big missing piece is that that education piece, and maybe people need to pass some sort of certification law before using it in course. obviously
Yeah.
that raises a lot of other challenges and things about it. But if we think about, this thing that we brought on the slide there now is, where people, what's happening now is people, they're essentially blaming the tool, or the tool being wrong when maybe it was the person that wasn't educated enough on how to use the tool. In that case that you mentioned before, where the practitioner was using rape, and they thought because they were using a legal practice tool that it was actually accurate. The problem there is not the tool. The problem is not necessarily the person. The problem is that there was a massive knowledge gap in the fact that this poor guy didn't know that he needed to go through and fact check everything that's coming out of it, and just swiped it verbatim, copy and paste them, and used it. In the case, I was reviewing a judgment yesterday or the day before, where a young guy, was doing 160 in a 60 zone, killed one of his mates as a little part, and maimed the other one to a point where his life is just basically worthless now. Who we think about the same principles applying here, they put up the 60 sign and said, no, you can't be 60 here. That didn't stop the guy from doing it. The car manufacturer didn't have a mechanism on there that stopped the car going 60 kilometers an hour, but the car manufacturer is not liable for what this guy did. But I guess if that person had had education around the implications of doing 100 kilometers an hour over the speed limit, his mate in the car, as part of the education process to be able to apply to get a license in the first place, maybe the outcome would have been different. Maybe it would have been the same, but maybe it would have been different having that piece of education or knowing what the outcomes could be and misusing the tool I think it's just going to benefit the community as a whole, because we're going to get the efficiencies. We're going to be able to solve a lot of the problems that are happening in the industry already, and hopefully we get better outcomes.
The other side of that, of course, is that that person is found criminally liable and has a criminal record for the rest of his life and serves time in prison for that offence. So if it's not the positive education in knowing how to use it properly, it may be the fear of the consequences as well. So it goes both of those sides. If all of that information and infrastructure is in place, it makes it safer to use.
Absolutely agree that the legislation is just one cornerstone to using. So far we've covered the legislation if we get it right, the education, and also the harder side of things, the restrictions that we as technology providers can build into systems to make sure that, I guess, the outputs are becoming more and more accurate. We're working on that anyway, but being able to work with regulators to get feedback on the types of things that they would like to see built into systems such as ours, that prohibit people from being able to misuse tools is, I think this trifecta of being able to, at least in the short term, being able to achieve the outcome that we're all looking for without having these huge prohibitive restrictions just blanket pasted across everyone.
Yeah. So we would be interested to hear you talk about the security assumptions, or the assumptions about the security of the tools that you would like to address in the practice note, because I feel like some of them were not quite accurate in terms of their understanding of how security is organised in specialised AI tools for legal practices.
Yeah, sure. I actually got a slide for that, as you can see here. So, great timing. As I guess most people will know, but no assumptions. Your data needs to be stored in Australia. If you're an Australian practitioner, your data needs to be stored in Australia. That's the first thing. Then, there's certifications that you can look at for legal tech providers or any tech providers, whether it's a basic ChatGPT or for this thing like that. But you really want to be looking at is the main certifications, at least as far as Australia is concerned. They are globally recognized certifications. your SOC 2 Type 2 and your ISO 27001 certification before using any software you want to be asking about these. Do they use end-to-end encryption for all of their data to keep your data safe? Do they have mechanisms in place like two-factor authentication? So even if your local machine was hacked, you want to make sure that wherever you're storing clients' private information, that is being kept in a secure way, and it's harder for people that are hacked in nefarious ways to actually get access to that client. So if you've got two-factor authentication, that's one way of being able to do it. The biggest point, and I mean the practice note does bring this up, but it's a little bit too conservative in my opinion, is that it basically says that all generative AI models take all of your private information and train, use it in their training to produce their outputs, which is just incorrect. So there are some models that definitely do that. And this is where, again, it comes back to education. It's more, this is more to go into than the time we have today. Happy to have discussions after this with anyone. But you absolutely want to make sure that your data is not being used, or your client's data more correctly, is not being used to train their own model. Because then what can happen is someone else can go and query that model later on and extract your private client information. And this is where the Supreme Court was being particularly cautious, is using information that's not yet public information or may never become public information to put into AI models that could then be used as training data, which someone else could retrieve at a later date. So two parts here. One is that the Supreme Court in the practice note was assuming all generative AI models will ingest all of your private data, which is just not true. Some, yes, but as a discerning lawyer, that's where it's your job to make sure that you're having the right conversation with people before you use any generative AI tool. It's not even every generative AI tool, it's any legal tech solution, or, even querying things like, uploading it to Microsoft SharePoint or things like that. I mean, you don't have to worry about it, but my point is the critical thinking goes behind using the tool before you're actually using it. Anything else I haven't covered around security?
Samuel, you just mentioned asking the right questions. In terms of questions that lawyers should be thinking about or asking of providers, what would the top 3 questions be, do you think, around security and compliance?
Number one, where is my data being stored, and is it going to be used offshore? As I just mentioned, I can't remember what the piece of legislation is. I'm just having a blank right now, but there is specific legislation in Australia around this. Maybe Jen probably is off the top of her.
And look, I'm not sure. Somebody in the audience will probably be able to correct me, but I think it's in the Privacy Act. Might be right, but I'm not quite sure.
Yeah. It's just escaped you for now. So the second question to just reiterate was, I would be asking, do you train on our data for the purposes of everyone else using the tool? And understanding how they treat the data, right? So it's not just about, no, we don't do it. Okay, pat on the back, off you go. It's understanding more nuanced way, you follow on questions around that to be able to ascertain, are they actually treating the data correctly? I guess if we look back at the SOC 2 Type 2 or ISO 27001, to reiterate what they are about, is they are all security best practices across the whole organization, not just around how your data is treated. They will cover the vast majority of things, but they won't cover things with generative AI, at least yet. The newer versions, I'm sure there's going to be newer versions of them come out that probably will cover it, but they don't cover it right now. And third, I can't remember what the question was. Top 3 security questions, is that what it was?
Yeah, top 3 questions practitioners should be asking of tech providers when considering what AI tools to use in legal.
Um, I guess maybe not asking the question, but look at all their terms of service. All right. So rather than that question, I'd be looking at their terms of service and their privacy policies, because they, there shouldn't be anything out of the ordinary. If you're using a mobile tech provider that's not generative AI based, the terms and conditions shouldn't quite similar. There's really no need for it to be drastically different, right? So if you're seeing unusual terms that are in a Gen AI provider that are not in the standard best practice terms and conditions and privacy policy of a SaaS provider, then that would raise flags that you want to dig further into.
That's great advice. Thank you so much. Does anyone in the audience have any questions for Samuel or Jenny? Feel free to unmute yourself and ask the question or pop it in the chat. Perhaps you can share some insights, anything that you've thought about since reading through the just note. I'd love to hear your thoughts as well.
Vic, I just noticed there's a question in the chat. The citation for that Victorian case I mentioned, it's Dayal, Dayal, square bracket 2024 closed brackets Fed C2, Fed C2F 1166. So it's in the Federal Circuit and Family Court of Australia, Second Division. But if you just Google Dayal, Dayal in Austria or Jade, you should find it.
Thanks, Jenny. We just have another question coming through from Karen.
While the question's coming through, maybe we can touch on, kind of where to from here in the kind of closing 10 minutes, Jenny.
Yeah.
How do you think about approaching not only the Supreme Court of New South Wales, but the other government bodies? And is there any way that people can get involved with what we're doing?
Yeah, look, I think that there's a couple of things that I can think of. One would be to see if people are interested in joining some kind of group to make representation to the Chief Justice, to ask him to reconsider some of the provisions in the AI tool, and to also think about a more rigorous structure for consulting in giving any guidance with this kind of tool. But I think also such a group could also think about whether we want to whether we want to approach the Australian Institute of, sorry, the exact name of the body, but the judges, basically the Australian Judges Association, and also the Commissioner for the Uniform Legal Profession Rules. So the three uniform rules jurisdictions have just put out a fairly brief joint guidance note, which is pretty good. But I think that there's a lot of opportunity and scope for knowledgeable practitioners to have some input into a body like this, to enable, I guess, a better regulatory understanding of what's going on. So I think there's a number of people that are quite interested in joining together and putting together some submissions to bodies like that.
Absolutely. And it's kind of in line with what we're thinking of doing as an organisation, an AI legal assistant, we're potentially opening up an innovators group. So, if you're interested in AI tech, obviously you're in the legal industry. We are really at the forefront of what's being developed in this space. So we've been considering, Beck and myself, opening a private group, innovators, people that are forward seeking in this industry and want to see the industry progress quite quickly with this technology. inherently what will come up is these sorts of challenges around, best use practices, bringing in things like, the legislation, but also balancing it with, as we mentioned, the education and also the hard side of things where we actually develop stuff with the technology that can prevent mishaps from happening. And people becoming complacent, right, and not doing their job because it impacts all of us, right? Doesn't matter which, if you're a self-representing person, up against someone else who is using it in, let's say, a less ethical way, or if there's practitioners that are bringing the industry down as a whole because they're not using critical judgment and best practice, and they're getting sloppy or lazy with their work, self-perpetuates if everyone is not playing with the same high standards. So if you are interested in joining this group, please let us know. We haven't officially announced this anywhere. It's something we've been thinking about for a few months, and it's kind of just brought it more to the forefront with everything that's going on the practice part. And lastly, I'd love to know everyone's feedback around some sort of education, potential certification. We are looking at, based on people's feedback, we would roll out a whole education series about using generative AI, best practices. We cover everything from your efficiencies and effectiveness to how to mitigate risks, how to telltale signs if you're receiving something from a client that they potentially generated with AI that may not be true. There's just so many potential use cases here or outcomes where things could go sideways. If the client provides you something they've generated with Gen AI that's incorrect, you could be potentially going down a rabbit hole. So yeah, we'll just open the discussion to anyone. Feel free to let us know in the chat or unmute yourself, and happy to have a discussion about it now at the time we've got left.
Thanks, Emil. I just wanted to share with everyone that I've just dropped my email address in the chat. So anyone that's interested in joining the types of collaborative working groups that Jenny and Samuel were discussing, please feel free to email me. We'd love to stay connected. And also, we really would love to hear your thoughts around the education aspect that Samuel has just asked you to join in the conversation on. Does anyone like to unmute or drop something in the chat?
I'm getting a message saying that I can't message you a chat because I'm not a member of the chat. I don't know why that's showing that, but hopefully that's not the case for everyone else.
I think it's the same with me. It says chat is not available right now. So to be some of the settings over there in the Teams, but I cannot access the chat too.
Okay, thank you for letting us know. We're clearly not Microsoft experts here. But
If anyone's got a question, unmute if you can't drop anything in the chat. Samuel Karen said, thanks, Samuel, Jenny, and Beck for an excellent overview of the New South Wales practice note and also using AI responsibly and ethically, which is why we're all here today.
Thank you, Karen. All right. Well, if there's no other questions for now, Prakash, did you have anything that you wanted to mention while you're?
I don't know. I was just checking out the chats, but I couldn't access it easily. So now I'm good.
Thank you. Thanks for letting us know. And thank you to everyone for joining in the discussion. Hopefully we can come together and put our brains together to come up with something that is more productive for the industry as a whole. Thank you, Jenny, for your time.
Thank you.
Thank you, Beth, for
organizing
it. Thank you, Prakash.
Thank you so much. And we'll be organising a follow-up webinar and live discussion early in the new year where we can regroup and look at what's happened with this webinar. So we'll make sure everyone that joined us today is notified of that as well.
Thanks a lot, Dave.
Thanks, everyone. Bye.